Imagine spending nearly 20 years creating a beautiful garden. Butterflies everywhere, birds nesting in the flowers, neighbors walking by with their children just to look at it. Then, one day, a lawyer sends you a letter demanding that you tear the entire thing out and replace it with grass. Not because it was dangerous, but because it violated a city ordinance? No. Not because it hurt anyone, but because your homeowners association decided the flowers were unacceptable. Most people would probably give in at this point. Janet and Jeff Crouch did the exact opposite. They sued, and their fight became so big that it changed Maryland law. Here's what happened. Janet and Jeff Crouch moved into their Columbia, Maryland home in 1999. Over the years, they transformed their front yard. Instead of a traditional turf grass lawn, they planted native flowers, pollinator plants, and habitat for wildlife. By the mid-2000s, the garden was well established. Black-eyed Susans, coneflowers, milkweed, goldenrod, plants specifically chosen to support butterflies, bees, hummingbirds, and other wildlife. The garden wasn't hidden behind the house. It was right out front where everyone could see it. And for years, nobody officially objected. In fact, according to Janet, neighborhood children often stopped to watch butterflies and other wildlife visiting the garden. Everything seemed fine until 2017. In 2017, the Crouches received an HOA violation notice. At first, the complaint focused on mowing and weeds, but Janet quickly realized something bigger was happening. The HOA wasn't concerned about a few weeds. The HOA wanted the entire garden gone. A month and a half later, the HOA's law firm sent what Janet described as a cease and desist letter. The demand was simple: remove the garden, replace it with turf grass. According to later interviews, the HOA attorney argued that gardens like theirs did not belong in the community. Think about that for a second, a garden being treated like a legal problem. For years, the Crouches had no idea what triggered the sudden crackdown. They learned something surprising. According to Janet, one neighbor had been complaining to the HOA for years. The neighbor reportedly disliked the garden and eventually submitted signed complaints that pushed the HOA into action. Imagine discovering that after nearly 2 decades of gardening peacefully, that there was one neighbor complaining, and that led to years of legal conflict. The HOA eventually held a hearing. Janet later described the process as unfair and heavily controlled by the HOA attorney. She prepared a statement, and her sister spoke about the environmental benefits of native plants. The hearing did not go well, though. The HOA ruled against them. The garden remained under threat. The message was clear: remove the plants or face legal consequences. At this point, many homeowners would surrender. The Crouches hired counsel instead. According to Janet, after living under the threat of losing the garden for nearly 2 years, they filed suit against Beech Creek HOA in August of 2019. Now the fight was no longer about flowers. It was about property rights. Could an HOA force homeowners to destroy environmentally friendly landscaping? Could a board decide that grass was acceptable but pollinator habitat was not? Those questions were about to get expensive, very expensive. Janet later estimated that the battle cost them more than $60,000. She also claimed the HOA spent roughly $100,000 pursuing the dispute. This dispute, all over the garden. This is where the story becomes bigger than a neighborhood dispute, though. While fighting the HOA, the Crouches began speaking with environmental groups and legislators for the state. One of those state legislators was Maryland Delegate Terry Hill. The issue resonated. Why should homeowners be forced to maintain environmentally harmful lawns if they wanted a pollinator garden instead? Soon lawmakers began drafting legislation, not for the Crouches alone, but for everyone. The result was House Bill 322, Maryland's low-impact landscaping law. The legislation passed with bipartisan support and became effective October 1st of 2021. The law protects environmentally friendly landscaping. That includes pollinator gardens, native plantings, rain gardens, wildlife habitat landscaping. HOAs can still regulate maintenance and appearance, but they can no longer simply demand that homeowners replace everything with turf grass. Maryland became one of the first states to explicitly protect these type of landscapes. The case itself never reached a full trial. Just before the trial, the parties settled. The Crouches agreed to modest setbacks from sidewalks and property lines. In return, they kept virtually all of their garden. After years of conflict, the butterflies stayed, the flowers stayed, and eventually, the law changed. The most surprising part of this story isn't that an HOA targeted a garden. It's that a dispute over flowers became a statewide political issue. A single homeowner complaint, a cease and desist letter, years of litigation, tens of thousands of dollars, and eventually a new state law. Not every homeowner who fights City Hall wins. Not every homeowner who fights an HOA wins. But in this case, Janet and Jeff Crouch didn't just save their garden. They changed the rules for an entire state. And that's why this might be one of the strangest lawn disputes ever to become law.